All right. Good morning, everybody.
Good morning, Your Honor.
First on my screen is Nicholas Arnett. Mr. Arnett, good morning.
Good morning.
And on behalf of Mr. Arnett, Mr. James Cravel. Mr. Cravel, nice to see you. Good morning.
Good morning, Your Honor. Happy New Year.
And you as well. Who you got with you other than that?
I also have a law clerk attorney with us, Taylor Brown, who is new to our office.
Well, welcome aboard, Ms. Brown.
Thank you, Your Honor.
Nice to see you.
Nice to meet you.
Nice to meet you as well. And our plaintiff joins us, Ms. Kalichewski. Ms. Kalichewski, good morning.
Good morning.
I have read your motion. Thank you for that. And I have read your response, Mr. Cravel. Thank you for that as well. Is there anything you want to add that's not in your motion that you wish me to hear today?
No, that's pretty much what my concerns were.
Okay, thank you. Mr. Cravel.
I will be very brief to reiterate. I don't think that either under Vadvarka, if we're going to change custody or change parenting time under Shade v. Wright, that the plaintiff has alleged sufficient facts to show us a material change in circumstances since the last order, nor proper cause. I don't think she even meets threshold. I do believe the motion may have been a little confusing, vague, or misleading, and I think we tried to clarify what I think her issues are and why they failed to rise to the level where this court should even consider modifying parenting time. And we're asking the court to deny her motion. Thank you.
Thank you. Well, one of the things that troubles me somewhat is whenever you have these situations and parents, I think one of the allegations, if I'm not mistaken, was there was some sort of incident between your client, Mr. Cravel, and his mother. Is that accurate?
It is.
Okay. I always, and I've read her letter, her statement as well. I always hate having grandparents put in the middle of these things because, as I tell grandparents who unfortunately get put in the middle of these things, grandparents have to be like Switzerland. They have to be neutral all times because they can't be an advocate for one or the other because then the other is not going to trust them. And then pretty soon they're in the middle of this hubbubaloo, and I don't want that. Now, from my perspective, the last parenting time order was this court's judgment of custody, parenting time and child support dated March 18 of 2022. The defendant, Mr. Arnett, has alternate weekends, I believe 3 evenings per week, 3 weeks in the summer, holiday times as parties agree. And it also gave the parties joint legal custody. I'm a little troubled about that argument, and I think that it may very well be something that the defendant may want to learn some tools of how to handle that again, if that happens again. So I'm going to respectfully deny your motion, Ms. Kalichewski, but I will require that Mr. Arnett enroll in and complete a 12-week parenting time class. I think, Mr. Cravel, that can be done at Fountain Hill, if I'm not mistaken, or the Y, somewhere around there.
What's the other alternative, Your Honor?
I think the Y has one. I think Fountain Hill has one. I'm not fussy about where it's at because they all do good work, but I think he needs to learn some tools as to maybe how to diffuse this when children are present, you know?
Okay.
Okay. Would you prepare that order even though it's not your motion?
I can do that, Your Honor.
All right, I appreciate that. Let's leave grandma and grandpa out of this, can we? I want them to be a source of comfort to kids. And if they think one is playing off the other, they won't be. So I think that will nip it in the bud, Ms. Kalichewski. Your concerns, I'm not saying they aren't valid, but I think I can fix them through this type of relief. So thank you very much. And we're adjourned. And Attorney Brown, nice to meet you.
Nice to meet you, Judge. Thank you.
Thanks, Your Honor. Everybody have a nice weekend.
Thank you.
By CPS. Mr. Perez did not file an appropriate motion to modify parenting time. Instead, he has threatened Ms. Gutierrez that he's not going to return the child unless she concedes to what he's asking for, which is not how we go about resolving custody or parenting time disputes. That's all I have to add, Your Honor.
Thank you. First of all, Child Protective Services was put on this earth to really do one thing, and that's to watch out for the safety and welfare of children. That's all they do, 24/7. So if Child Protective Services says that it's safe, then it's safe, okay? Now, I don't know if even close to what the allegations are, but the bottom line is this. The last parenting time child support order was not that long ago, April 5 of 2024. And the last custody order was January 19 of 2024. And that granted to plaintiff mother sole legal and sole physical custody. I understand CPS's safety plan to stay with Mr. Perez while these things get sorted out, but they've given the okay for that to happen. And there's a whole line of cases that would support Ms. Gaston's position. Thoreau versus Dorr, 137 Michigan Appeal, 147, and 1984 case. Spears versus Spears, 108 Michigan Appeal, 543, a 1981 case. And Straub versus Straub, 209 Michigan Appeal, 77, a 1995 case. So I'm going to grant your motion, Ms. Gaston. The child is to return today by 5. This matter will take interim effect, and you may use law enforcement to enforce that if necessary, Ms. Gaston. As results of, as far as makeup parenting time is concerned, I think what Mr. Perez has is every weekend but one, I think is the way it is. So let's start, from your understanding, Ms. Gaston, is it the first weekend or, yeah, the first weekend of the month goes to your client, correct?
Correct. So she missed one weekend.
Yeah, and I'm going to make up for it by having the child to her by 5 today. And then after that, it will go to the regular rotation until the 1st of March, the first weekend of March. And that will go to your client. And the second week of March will go to your client. And every month thereafter till all the time is made up in this case. So that's what the law says. I'm going to grant your motion, Ms. Gaston. Anything, any questions on what the order needs to say?
No, Your Honor, I'll prepare the order and get it over hopefully today.
You can send it. However, You're all set. Thank you very much to everybody
you.
for adjourned.